Now here's something we hope you'll really like.
But there is one voice that has never been heard before. The voice of old Mr. World himself. The way he might sound if he could speak to us in our own language. Mr. World, how was this wonderful, orderly earth of ours formed in the first place? And how long has it been going on?
Well, if a few people do decide to swing one way or another, it might actually pass.
This property was used to manufacture marijuana.
And the judge said he needed a timeout, so he took his belt and his shoes and his tie and put him in the lockup.
We're traveling through a dimension both of sound and ideas. We're at a place where the mind can comprehend and devise a wireless transmitter, measure time and light.
Have you ever met anybody before who's been busted
but you can
on
find it in a
marijuana
place
charge?
that's known as
This year,
Green Tree Show. Attorney Michael Komorn.
every 35 seconds. 90% for possession only. For the first time since marijuana was made illegal in 1937, Congress is finally looking at a bill to re-legalize marijuana. The U.S. Congress is considering legalization that permits individual states to set public policies that will allow them to legally control and tax marijuana. To find out more about this important congressional bill, please contact NORMAL at 202-483-5500 or on the web at normal.org.
The life I love is making music with my friends, and I can't wait to get on the road again.
Alrighty.
We have launched.
Alrighty. Welcome, everybody. Planet Green Trees. I'm your host, Michael Komorn. It's officially episode number 313. What could you call it? The Detroit 313. But instead, we're calling it Blood on the Slacks. Maybe I'll explain that later. But tonight, we're about to embark on 2 hours, give or take a minute here or there, of nothing but entertainment regarding marijuana reform in Michigan. Medical marijuana may be included as well. But as I like to say, let me introduce to you the community entertainment. Beside me, to my right, the technical director, who's got a lot on his plate. He's juggling 4 or 5 chainsaws right now. Chad from the Birmingham Compassion.
Good evening. It's nice to be here.
Sliding over to the other side there, we got Rick Thompson, Compassion Chronicles founder, editor-in-chief, and the Planet Green Trees news director.
Good evening, everyone.
Alrighty, our producer, working very hard. Didn't get to talk to him at all today. Just wanted a Tiger shirt today. Way to support it. Jamie Lowell.
Hello. Don't forget to check out Komorn Law, MMMA, Planet Green Trees on Instagram, Twitter, and Mass Roots.
Excellent. Good job. He's from Third Coast Compassion Center. Beside me right here, from Michigan Parents for Compassion and the co-founder and board member of MILegalize, Jim Powers.
Hi, everybody. Good to be here tonight. Glad to be winding down after another crazy week.
It sure has been. And, of course, esteemed lawyer extraordinaire, guitar player. Beside him, I think. Internationally renowned. Please welcome Jeff Frazier.
ANG. In other words, the task force formerly known as FANG.
That's funny. We have here to define what beauty means tonight, Schuyler Engel, attorney, counselor. Welcome, Schuyler.
Thanks, Michael.
He's a Federalist. Don't let him out of your sight. All right, so tonight's show is very exciting. We're going to be discussing the Michigan Court of Appeals defines what a plant is for the purposes of the Michigan Medical Marijuana Act. Is the definition of the court that a clone with visible roots constitutes a plant of functional interpretation for those patients and caregivers participating in the Michigan Medical Marijuana Program. We're going to discuss that, of course, and also national organization, the Minority Cannabis Business Association, visited last Saturday And to hold its diversity summit, we're going to be talking about that. There's going to be a MILegalize fundraiser at the Four Winds Casino Resort on Saturday, August 20th from 4 to 7, located at 1111111. How many? Wilson Road in New Buffalo, Michigan, the southwest corner of the state. And joining us tonight, we will have the Vice Chair of the MCBA, Jeanette Ward. Should be calling in. Is that right, Jimmy? That's right. Okay, all right. And we have many of our regular guests. I do need a couple shout-outs if I have time. I want to give a big shout-out to our Dewey and Pam, of course. We got to give a shout-out to Bob Redden and Knucklehead Bob, David Light, Pam and Dewey. There's some people that aren't here and unaccounted for. We should say hello to them, of course, are Eric Gunnels, Theo, what? Theo, that's right, Charmy Goldston. Is Jeanette Warner showing up? She's on the list. Okay. And I think that's it. So we're going to go to a break in a little while. Let's, Rudois, of course, and the persons over the Michigan Medical Marijuana Association.
Bob and Carrie.
Bob, Redden, and Carrie, of course. Keep going, more. David Light for our art director.
Jim again.
Jim Powers for being here. What is that? Okay, that's a break time. All right. So I know we're working on the new shell, close to I think our initial breakaway. But when we come back, I'm gonna rant a little bit, and we're gonna talk about Court of Appeals opinion. I may get into that a little bit right now, and also the business that was taking place in Detroit. Jamie's going to talk about that. Just on Planet Creatures, we are going to be right back. Timing's excellent so far, if I can't. Let me say so.
The Planet Green Trees Show.
Join the Michigan Medical Marijuana Association today. MichiganMedicalMarijuana.org. The MMMA is focused on the well-being and safety of medical marijuana patients. The MMMA site provides the most comprehensive and up-to-date news on legal issues, politics, research, cultivation, as well as the various strange products and methods of cannabis use. Come join the discussion with the most knowledgeable and passionate advocates in Michigan today. MichiganMedicalMarijuana.org.
If you missed the last Full Melt show,
you missed a lot.
There's King Tut. You know why I wanted to bring up King Tut? But they actually dug up in Russia some ancient bongs. They're like 2,400 years old.
Yes, that's fucking awesome.
They're golden.
Oh, my God. 2
ancient golden bongs found in the Arctic tundra of Russia.
They were getting high, man. Yeah.
And I guess they traced it back to the early tribes that populated, the Russian tundra. Those tribes used to war against each other, and they would get high on the opium and the cannabis before going to war. Go figure. I'm just saying, there's somebody was selling golden bongs. And get your golden bongs here, golden bongs. It had to be really hard back in those days to come up with gold. Except for maybe Colombian gold.
Oh, my God.
Hey, the trade winds are blowing smoke in your face. Fantastic guest bloggers, incredible photography, and cutting-edge information separates the Compassion Chronicles from all other websites. Sign up for your newsletter today. Since 2012, the Compassion Chronicles has been delivering news and information for Michigan's patient community and beyond. From breaking news to science articles to networking and event information, Michigan turns to the Compassion Chronicles when patients and caregivers need to know the score. Edited by Rick Thompson, winner of the Crystal Trichrome Award for Journalist of the Year and named Citizen Activist of the Year 2015 by the Weed Blog. TheCompassionChronicles.com. And now back to more Planet Green Trees.
Alrighty, we're back. Thanks for staying with us. Listen to Planet Green Cheese episode 313, Blood in the Slacks. This is my section to rant a little bit, Jimmy. Talk about some stuff. I may even invite some further commentary from the lawyers in the room. Maybe. If everyone's ready to talk about that case from today. Charlotte, are you ready? All right. So, good news. U.S. Department of Justice, Office of the Deputy Attorney General, announces today, August 18, 2016, a memorandum for the Acting Director of the Federal Bureau of Prisons. From Sally Q. Yates, Deputy Attorney General. Subject matter reading, reducing our use of private prisons. This is big news, exciting news. I don't even know if people understood or realized that the federal government was, in fact, contracting with these prisons. Many may have thought that it was at the state or local level, but it appears from the outline of this that's very clearly disclosing that between 1980 and 2013, the federal prison population increased almost 800%. 800%, often as far faster rate than the Federal Bureau of Prisons could accommodate. And in an effort to manage the rising prison population about a decade ago, the Bureau began contracting with privately operated correctional institutions to confine some federal inmates. By 2013, as both the federal prison population and the proportion of federal prisoners in private facilities reached their peak, the Bureau was housing approximately 15% of its population, nearly 30,000 inmates, in privately operated prisons. Since then, for the first time in decades, the federal prison population has begun to decline from nearly 220,000 inmates in 2013 to fewer than 195,000 inmates today. In part, this is due to several significant efforts to recalibrate federal sentencing guidelines, including the retroactive application of revised drug sentencing guidelines, new charging policies for low-level nonviolent drug offenders, and the administration's ongoing clemency initiative. Those are all words from prison reform or justice reform. Am I right? Is that what that sounds like?
Yeah.
Okay. Now, 3 years ago, the Department of Justice announced its Smart and Crime initiative. Our efforts to address the pressure facing the Bureau are seeing real and positive results. Private prisons, the memo goes on to say, served an important role during a difficult period, but time has shown that they compare poorly to our own Bureau facilities. They simply do not provide the same level of correctional services, programs, and resources. They do not save substantially on cost. And as noted in recent reports by the Department's Office of Inspector General, they do not maintain the same level of safety and security. The rehabilitative services that the Bureau provides, such as educational programs and job training, have proved difficult to replicate and outsource, and these services are essential to reduce recidivism and improving public safety. For all the reasons, the director goes on to state that they're eager to enlist the help in beginning the process of reducing and ultimately ending our use of privately operated prisons. As you know, all the Bureau's existing contracts with prisons companies are term limited and subject to renewal or termination. I'm directing that as each contract reaches the end of its term, the Bureau shall either decline to renew that contract or substantially reduce its scope in a manner consistent with law and the overall decline of the Bureau's inmate population. I'm aware that the Bureau is already taking steps in this direction. 3 weeks ago, the Bureau declined to renew a contract for approximately 1,200 beds. Today, concurrent with the release of this memo, the Bureau is amending an existing contract solicitation to reduce an upcoming contract award from a maximum of 10,800 beds to a maximum of 3,600, concurrent with the releasing of this memo. Upcoming contracts will also be reduced. Taken together, these actions will allow the Bureau to end the housing of inmates at 3 or more private contract facilities over the next year and reduce the total private prison population to less than 14,200 inmates by May 1st, 2017, and greater than 50% decrease since 2013. So this is good news, and interesting nonetheless that the federal government's taken a position that they don't want to direct the motion of the government and the efforts and resources that are utilized to imprison people in the prison system, and let alone in a private prison system. I think this is very, very good news. And it's no mistake that it's long been criticized that the private prisons do not employ any of the same types of resources or quality services that are needed and utilized in the federal Bureau. But here they are being called out and identified as being one of the other inherent problems. So this is good news. And as we also understand, the stocks for these major institutions of the private prison systems fell off the charts. And personally, I couldn't say that it hasn't happened to a nicer group of people.
Yeah. Woo.
I remember in part of stock portfolios, it's not uncommon to include the private prison as one of them. And the selling points have always been that, and I've heard it. You've heard the announcements of how they try to sell the stocks for private prisons? It goes something like this. Every year we send more and more legislatures to Washington and locally to make more laws. These laws aren't designed to keep people out. They're designed to find laws to arrest people and put them in prison. This is an ongoing thing. If we keep electing people, they are supposed to create laws. More laws mean more arrests, mean more bed spaces needed. Also, as these specific marketing tools and sales pitches to buy the stock will go on about. And there's the immigration issue. What are we going to do with all those people? Clearly, we're going to lock them up. We need prisons for that, too. And, of course, the war on drugs is something that has fared very, very well for the private prison industry. And clearly, that's something that also will continue. And there's so many terrible drugs out there that people will obviously get addicted and sucked in and start committing crimes and need beds to be placed in the private prison system. But this is good news because we don't need to build them and then put them in there. I think it's time to start reflecting differently on how this has been too much of a policy of lock them up and ask questions later. All right, so that's the initial part. Got a few more minutes, I think, to go on here. There was this interesting case came out, Lorenzo Enrique Ventura. We're talking about this as part of the show, too, right? Yeah. And it's a case of first impression in Michigan, namely what constitutes a marijuana plant. Right. Although one could say it's really not an issue of first impression because these things have been known for a long time. Right, statute. There's a statutory definition of what marijuana is, and there's a definition of what a plant is. And neither of those are included in this finding. They oddly adopt a definition that is not one that is found anywhere in the dictionaries, Webster or other, and essentially create a imaginary concept and insert it into the... This is federalism, isn't it? Is it federalism? Like you can't listen anymore? Am I wrong? Am I wrong? I am wrong? No? All right. Well, I know this. I know that the definition being used here is that if it's got a root on it, they conclude, it's going to be considered a plant. But that is not the definition of what a plant is or should be, even under federal law. Schuyler, Federalist. Federal law would require...
You missed the last Full Melt show. You missed a lot. That's what's been going on. There's been...
What happened?
That was my bad.
Okay.
That
all
was
right.
me. Accidental.
That's fine. So, so what is the root formation? And they pull out a Idaho Court of Appeals case and find out what the definition. But I will say this: the many of the drug task forces, and I've had the opportunity, been blessed to be able to cross-examine them, will utilize this concept of the root visible. It may be from federal law, some of their training that they may receive in their secret hideouts and back caves that they hide in of unregulated activity for forfeiture and other. They may be trained about and brought in and are affiliated with at various times some of the funding associated with the federal DE agents, so that would make sense that is the case. But it certainly is not contemplated, I think, in the Michigan Medical Marijuana Act. And it also is representative, I think, of something that is oftentimes missed in these Court of Appeals opinions, which is that when there is inherently a conflict, instead of acknowledging the Michigan Medical Marijuana Act with specific language of conflict resolution shall be in favor of the Michigan Medical Marijuana Act, including the Public Health Code. You okay with that, Schuyler? Does it not say that?
I'm sorry, I didn't hear what
I'm talking about the conflict law of the Michigan Medical Marijuana Act as it relates to the Public
Section
Health
7E.
Code. Do you know what I'm talking about?
the conflict that... Well, you're talking about basically Mazer, essentially.
I'm talking about the statute itself has 7E.
Yeah, sure.
Very specific. Any law that conflicts with the Michigan Medical Marijuana Act loses. Okay?
Sure.
So in these instances, when the Public Health Code and other definitions come into play,
sure,
there is a default to the Michigan Medical Marijuana Act. The Michigan Medical Marijuana Act starts with the proposition that it is intended to reduce the number of arrests. Okay? So any and all interpretation must begin from that specific position. Do you agree with that? Is that statutory interpretation?
I actually,
is that Federalist?
I just argued that today. And yes, of course, I agree with that.
All right. So if we start with that as the proposition, what would you let's talk about this. Because oftentimes I find myself beating my head against the wall with some of these Court of Appeals opinions. And we can argue that it's political. We can argue that it's, Peter O'Connellism or whatever. Peter O'Connellism. Peter O'Connell. Court of Appeals Justice. Yeah. So, but my point is that, take any one of these opinions. Take all the opinions from the Court of Appeals that has looked at this law and ultimately said, this is how we're going to interpret it. The Supreme Court goes, no, it's not even close. Sure. Okay. So they've been wrong a lot.
Yes.
They're wrong here. They're wrong all the time. It has to be based in some, concept. They weren't elected. They weren't, put on the ballot, or appointed, maybe, probably, just because they were going to do the right thing, so to speak, and take care of those that, philosophically agreed with them. There's got to be a basis. How do we get here? What is this? What is this crap, this terrible opinion? How do we get here?
I can't fix all the problems right now. I'm like...
I have a theory.
Go ahead. You have an idea. I don't know how to fix all this.
I think that it's definitions. I think that they're lying about the definitions of words. And here's what they did. They wanted to make sure that every single thing about the marijuana plant was controlled. So they said anything from a marijuana seed is marijuana. And they didn't contemplate the fact that there would be clones. And they defined themselves into a box. That's what I think.
The problem is that there is a definition of, seeds are...
Well, a cotyledon is, by definition, something that comes from a seed. So by definition, only marijuana plants that come from a seed are marijuana. Clones aren't, because they didn't come from a seed. But I think the reason they did it was to try to control everything about the marijuana plant. It's a theory.
Yeah, but they also make a plant in the public health code. So it does cover everything.
But it doesn't have roots.
But as soon as it grows roots...
Then it's not a cutting anymore.
Right, but it came from a plant with cotyledons.
It's within the definition of marijuana, any part of the plant. So it's marijuana. Right.
It is marijuana.
But the problem is that they are trying to now identify that there is marijuana. And this is really an important point, I think, is that they're recognizing there's marijuana, there's plants.
We're talking about for plant count.
Right, because we're talking about for plant count, exactly. This is a decision that was made to take the counting of plants and exasperating that count to the highest exponential way that you can, identifying everything as being a plant to find people in violation of Section 4.
Right. Yes.
So again, it's really hard to basically make sense of an opinion you completely disagree with. But if I were the appellate judge, I would have just simply looked to plant as defined in the public health code. It is. I don't know which law clerks fell asleep in not finding that. And the public health code 333-7401, this is what we defend against all the time. Subsection 5, as used in this section, plant means a marijuana plant that has produced cotyledons or cut of a marijuana plant that has produced cotyledons. Why was that just not the first sentence?
Right.
That's what this ruling should have
been. It only
been.
applies to that section.
Because under that definition,
might as well use some completely different definition.
I'll tell you what.
The Court of Appeals, first paragraph. This is the first paragraph. Says, the word plant has never been interpreted.
It's ridiculous.
What are you talking
Listen
about?
to me. Listen to me. Yeah. If they adopted that, what would happen? The cops would have to take pictures of the cotyledon.
Yes.
They'd actually have to do their job. Do you know what they do now? They're going to say, "Oh, I saw a root." They're going to throw it in a bag.
That's right. Yeah.
Okay, do you see what I'm saying? Or they're going to or what they're going to do is keep. This is another thing. They're going to keep them in the. I've had this case before. Listen to this. They take them in the cloner, intact, to the evidence room.
Okay.
And when they go to examine it and count it, a couple days later, you got a shitload of roots. I'm quoting Jim Powers. Because they don't need sunlight to grow. They're intended to grow in the dark, right? And
they're like, holy crap, there's no light or anything. I better get some roots. They don't say that, but it's like that.
Roots is a red
chemically.
herring. It's about the seed. Do they come from a seed or not? It's like natural versus synthetic. In this case, the question is the definition of a plant in the public health code that talks about a plant that comes from a seed. I think, there's a very good argument that clones don't come from a seed.
And therefore, they would not make out the definition of a marijuana plant.
Well, we're not saying it's not marijuana. I'm just saying when it comes to plant count, I think they painted themselves into a logical corner. If they can't count clones because it doesn't fit the definition of a plant. That's why you see this gobbledygook.
Right.
But that's not what the appellate decision said.
Well, clearly not.
We're stuck with it for the time being, and it's frustrating because as a good textualist, I just simply want to look to the statute that exists, and it just says, are cotyledons there? Yes or no? That should be it.
And it only mentions roots in that they don't count. And you can't weigh them.
None of the root ball stuff matters. That's just what cops been trained as. That's what the federal sentencing guidelines say. That's
so
it.
It's a definition of marijuana. It doesn't include roots.
They probably weren't taking clones into consideration when that, as Jeff said, when that definition happened. So in order to have a functional definition, they have to include something about clones. Why isn't that okay?
So actually, when I'll be honest. Until this opinion came out, I hadn't researched it that much, but in my interpretation of this actual provision, I think it doesn't anticipate clones because it specifically says, or any cutting that has grown these cotyledons. So I think that specific.
The question is whether clones may not produce cotyledons.
Well, cloning technology has been around for a long time, and it's been used in a lot of different horticultural fields beyond marijuana. So that was a known entity, even in '61 when they originally did the whole single convention. Cuttings are mentioned back from the United Nations days. So that's it's kind of standard phraseology.
I just think that this was a really simple opinion that they, even in 5 pages, made it unnecessarily complicated and came to the wrong decision.
What is that? Has
Oakland
never
County?
happened.
Oakland County. What?
The Court of Appeals has never done that.
I tell you what this does do.
I
tell you what it does do. It clearly provides for an entire new area of litigation of the selling and transferring of plants. Talk to me.
Oh.
Segment's ending.
Oh.
Am I right?
Okay. That's terrible that we're going to play it that way, but yeah, you're right.
I am right. I've been talking about this for a long time. That there's a specific definition now of what a plant is.
And so we just transfer the non-plants.
Well, no, what I'm saying if you
cut off the roots.
Well, then it's marijuana.
Everything's going to be just unusable.
I'm saying
marijuana
selling marijuana. The Darryl Berry case.
Yeah, everything's.
Where is he? Is he listening? I hope not. Do you know what I'm talking about? Right? It's the plant sale.
Selling the mature plant.
It's not a prohibited act.
No, I mean
it's absurd.
It's something different. And I'm saying like this by defining it so poorly and making it the clear distinction of marijuana and a plant, and going to the extent that they do of all these things being a plant. You got to look at how the case laws has been played out. It has always been issues of marijuana. They have a definition of marijuana in this opinion. They clearly differentiate what marijuana is. Every single case has been litigated about marijuana. Now we have a recognition that marijuana is something different than, even though we all know this, and is going to be looked at differently as a plant. So could we say that McQueen was about who can sell marijuana to who? Yeah. But did it talk about who can sell marijuana plants to who?
No, not specifically. I mean,
they're different things.
They're different things by this case.
Usable marijuana and plants are different things.
Well, with all these interpretations coming out, there's a whole lot of unusable marijuana. And now, we see that these cops are actually, processing this marijuana, removing stems, removing leaves.
What do you mean? When did you have that?
About a year ago.
St. Clair? out
St.
there?
Clair County.
They
Would be surprised.
yeah, I think it's St. Clair.
Yeah, they got into trimming marijuana
They were
for a
trimming it?
while.
Yeah, no, they
Yeah.
didn't.
Well, what they said,
Maybe they bought
what
it.
they said in our
Blood
case,
from
what they said in our case, and I reread that lovely's, Her Honor's opinion, where she did not think much of it because they do that kind of stuff all the time. What she didn't recognize was the reason why they did it was because lawyers like you, Mr. Komorn, as they said in the transcript, would argue that it wasn't usable. So we wanted to stop you from being able to utilize the law as it was written to protect people, and we wanted to dry it so we could screw you over. That's what they said. That was her. Anyways, we got it.
That was totally cool with her too.
Hey, listen, while we're talking about definitions of cannabis, the United Nations single convention, yes, defines cannabis as the flowering or fruiting tops of the cannabis plant from which the resin has not been extracted. So under that definition, that's all just the fruiting tops.
And that's the way it should.
That means
Yeah.
male plants, immature plants, clones, they are not considered to be
They were never
controlled.
They were never supposed to
That's
be.
the logical way, because until the
be.
THC is produced, technically there's no quote-unquote danger present.
Well, there's nothing that should be controlled. I mean, it'll die without, ongoing
Talk about sanity.
care.
Sanity from the UN for crying out loud.
Yeah.
Michael, we're just about up to section break, I believe.
All right, very good. Very good. Okay, so when we come back, I have no idea what's going on, Jamie.
We're going to talk about the Minority Cannabis Business Association with the vice chair, Jeanette Ward.
Calling in.
Get her on the line.
We should get her here in person, but I
She
think
is
it's too
going
late.
to call in, I believe.
She's in Oregon. That'd be a long drive.
I want to talk about the distinction of plants more.
So launching on Spreaker, too. It's fantastic. It's exciting. Planting green trees.
High quality audio.
You're gonna-
Chad is over here just shaking with excitement.
You're going to hear Michael's voice with all its timbre and its magnificence.
If you're having issues on Blog Talk Radio with volume, then you may want to try out Spreaker. I know that there's some issues with the Blog Talk Radio transmission right now. I understand it's pretty low volume. We're going to try to fix it at the next break, but here we are. We'll be right back.
Already. There may have been a little
We're
bit of...
back. Everything's cool. Everything is not cool. Everything is cool.
Whatever was going on, that would be Chad's fault. Get Rick on. Chad, come on.
Chad Reno. Hey, we're all recovering. It was a body blow. That sound, that horrible noise.
It was bad. That was painful.
It's okay. We're cool, and we're all survived. So we have an exciting call-in guest, do we not?
That's right. Our next guest, Jeanette Ward, is the Executive Director of Data and Marketing at MJ Freeway.
Yeah.
Business Solutions, the world's market-leading cannabis software company. Before coming to MJ Freeway, Jeanette's been 15 years in the corporate sector and senior management roles in marketing, data, and communication for companies including Coca-Cola, the Home Depot, and UPS. And Marijuana Freeway Business Solutions is the cannabis industry's market leader of software small business customers. Let's get Ms. Ward on the phone if we can.
And, of course, she is the vice chair for the Minority Cannabis Business Association, which is the main point of the discussion.
Very good. So, Ms. Ward, can you hear us, Jeanette?
That's no bueno.
Yes, we are working on that. Okay, we got it, Chad. All right. How's that? Is that better?
Yeah, wonderful.
Fantastic. All right. So, tell us about the organization you're vice chairing right now and why you wanted to get involved with that.
So, I'm vice chair of the Minority Cannabis Business Association, and we are the first nonprofit created to serve the needs of minority cannabis entrepreneurs, employees, and patients and consumers. I wanted to get involved in it because I believe that the war on drugs and its unfair targeting of people of color, specifically African Americans, that we can do something about that and help level and equal the playing field through the opportunity we have with the cannabis industry to ensure that there's equality, that people of color have the opportunity to benefit, and that the tax revenue that will be significant from cannabis is invested into communities impacted by the war on drugs to help rebalance the economic detriment done by the war on drugs.
That is a fantastic platform.
Well said.
Yes.
Thank you.
We're all in Michigan here, and I'm surrounded by activists and lawyers, and every Thursday we get together and talk about medical marijuana reform, and we haven't evolved to the point where we actually have a regulated industry as of yet, so we haven't yet had opportunity to experience the racism that's going on in other states for minorities that want to get into it. What states are you talking about that your messaging is being received? What specific states?
So issues of equality in cannabis really center around first the high cost of entry in some states. So if you take Pennsylvania as an example, I believe that licensing fee was $200,000 and you had to have $500,000 in liquid capital. New York had similar really high licensing fees, and in New York you didn't get it back. I think their licensing fee was actually $500,000 and you didn't get it back when you applied, and if you lost, you just lost that money. That kind of money, that kind of capital is not usually available to people of color at the rates that allow us to compete equally in the industry. The other thing that happens in states like, again, in New York, is they have limited licenses. And so those limited licenses mean that only the few in terms of can get a license, and often that can have something to do with relationships. If you don't have relationships with the right people already, if you're not connected, you're not going to get a license. So we like unlimited licensing, like Oregon, and we like low licensing fees that allow people to start a small business the way you can start a small business in any industry. If I wanted to start a restaurant or a hair salon, there are licensing fees, but they're not prohibitive in such a way that it's going to block me from being able to get into the industry.
Isn't really the bigger picture that we're all you got a corporate interest that is coming in and competing for and participated in, obviously better funded than, the average, small business owner in general. Is that the primary antagonist in your messaging?
Well, so you might have a group of people who, I was talking to a guy from Pennsylvania who considered himself the everyday man, and it was him and his few investor friends who were getting together to pull together that $200,000 to apply for his license and pull together that $500,000 in capital, liquid capital that he had to show in the bank to apply for the license. And I thought that it was ironic that he considered himself the everyday man because, I don't personally necessarily know enough people that I could pull together that kind of money, but I appreciated him saying he was the everyday man. So it's not always corporate quotation mark interests. It's just a level of required capital that's beyond what people have. And that works well for anyone. I mean, we have veterans who are interested in our organization because they support what we're trying to do. By leveling this playing field, it doesn't just mean it opens it up for minorities. It just means it levels the playing field. You've got a great idea and you're going to work hard. You've got that opportunity to, I'm going to be corny here, but pursue the American dream because we're not blocking people by making this high cost of entry.
I agree. I mean, I think that's actually, it's been I think that's been the challenge to our economy in general, the ability for the small business owner to thrive and, succeed in business with some of the inherent challenges of, the big business. I mean, it's very rare you see grocery stores anymore that are mom and pop. They're all, bigger, Costco-driven types of, and I don't know that that's
absolutely
good for the community. Does the organization exclusively work in the cannabis funding and advocating?
We do, yeah. We're just focused on cannabis.
Can I ask, to what extent the assistant is? Are you advocating on behalf of in the licensing process? Are you helping to fund? To what extent does your involvement go?
Yeah. So what we do is we do advocate. So the first thing we do that is what we spend most of our time and effort on is policy. So advocating for the policy that we feel is the right policy to ensure equality in the industry and drive more diversity. So that's lower licensing fees, unlimited licensing. We also advocate for the investment of cannabis tax revenue in communities impacted by the war on drugs. So Portland, for example, is going to vote in November to invest tax revenue in communities impacted by the war on drugs and specific programs around economic development and job readiness and preparation, record expungement. So that is definitely the number one thing we do is that policy advocacy, and we do that across the U.S. And then we have education for our members. So our members who are starting cannabis business, and I mentioned, you don't have those networks and you don't have, know people already in the industry. So we have education, we have networking to create an environment for our members to begin to get a foothold in the industry. And then we have programming that we do specifically around communities impacted by the war on drugs. So Marley Natural, we've just partnered with them, and we're having an expungement day in Oregon, and we'll do this in other states as well. But our first one's in Oregon on August the 27th, where we will be expunging records for people with cannabis convictions. So it's saying, what do we do in the cannabis industry? And then what do we do with essentially cannabis profits to do good and to improve the economic condition of the communities impacted by the war on drugs? Because you have to look, you can't just look at the legal cannabis industry, we feel, without looking back at the detriment that the war on drugs caused in our communities. You've got to look at both and address both.
It's such a great mission that you're on. May I ask, is there like investors? Are you getting funding from government? What's funding the cause?
We get funding from companies in the cannabis industry, so Marley Natural, MJ Freeway. We've got companies that write us checks and support us, and we appreciate that. They're our sponsors. And then our members do pay to be members at certain levels. So you get more benefits at certain membership levels. And so we have 3 different levels, one of which is free, 2 of which are paid. And then so that's another way we get support.
I have to tell you, I thought that when I originally asked, like, what areas were you guys working in, I thought you would have said Colorado or California, maybe, but you didn't mention those. Are those states that have been? I mean, that is, that to me, like, I just see this being like that's an industry. It's been regulated. All the other states, while they may have legal, recreational, they still haven't gotten to the development yet of an infrastructure and regulated. There's I'd say not to the extent of Colorado. I don't think we're far away from that, but. Is Colorado off? Is it like a no entry for anybody, or is it just not an area that you think would be plentiful?
I don't know if I totally followed that. Were you asking, are we working in Colorado?
Yeah.
Yeah, we work in all the states where cannabis is legal. And so like you said, some are regulated, some are not. Colorado is regulated. California is not. Oregon and Washington are regulated. But we work in those states either way. Because where they're not regulated yet, like Michigan, what you guys have coming could negatively impact diversity and equality in cannabis. So we do look at all those states and work in all of those states, and we have policy and recommendations that we make and how all of those states are moving forward with their regulation, because regulation is always changing. So even in regulated states, there's always evolving regulation that we want to get involved in.
So you have some sense of what's happening in Michigan in terms of the pending legislation and how it's been held up, and
correct.
All right. But do you view it as being one that, as it exists right now, and there's been several amendments, but it's basically it's like a license that for selling, transporting, storing, and retailing. And what's your thought? What are your thoughts on that? Professionally, you think that that's one that would help forward the message and the in the development of minority business?
Well, so one of the things I like right now about Michigan is that it doesn't have high cost of entry, and I know Michigan has been great in that Michigan has been. Cannabis business owners have been very well represented as people of color, as they should be. So I also like very much how active the Michigan cannabis business owners have been in ensuring that in working together and building their own coalitions like Sons of Hemp, and ensuring that as these new laws come out, they manage to stay in business. So one of the laws that's quite common is to not have a dispensary within 1,000 feet of a school or a place that serves alcohol, or like a liquor store. So that, although creates a problem for these cannabis businesses who are like, well, then where can I be? Especially like where does that leave me to have a cannabis retail store? And so they've been able to push some great things forward to adjust those laws so that they can continue to operate.
Let me ask something else, because you mentioned, and I see this as one of the issues that's happened in Detroit, and I understand it's not uncommon in other, urban centers where the community, the neighborhood leaders, community centers, the, and many of the legislators, locally, are not. They don't see medical cannabis and cannabis. They don't see the bridge here of the problems that the war on drugs has caused to the community, and there's antagonism to it, and they see it as alcohol and all the destruction that those shops started up. That's my sense of what's happening in Detroit right now. And it's misses the message. I think like there's a lot of education, but is that common throughout? And how do we change that?
It is very common. There's so much education that needs to be done with with the average citizen about what cannabis is as medicine, and just about who cannabis business owners are and their interest in their community and their concern for the health of the patients they serve. I don't know if you see that in the industries and with liquor store owners, and I don't want to talk negatively about liquor store owners, but if we do a better job, and this is on us as well, talking about my organization, of educating around what cannabis medicine is and who these cannabis business owners are and why they're doing this. They care about their communities. They care about serving these patients and people, benefiting from this medicine. And that's such an important point, that people do see it that same way as you might view a liquor store in your community, and it is not the same thing. And it brings, in a liquor store, you don't typically have to have a lot of people working to support, local people working to support that store and support those products. But you do with cannabis. You've got a group of people who are growing. You've got a group of people who are running the store. And so it creates jobs in a way I don't think liquor stores do in the community. So you're right. It's different, and we need to do a better job of educating and showing communities that.
And I think that, obviously the message, the war on drugs and who it's mostly affected, that is not the first, concept or principle. Also, talk to me about the clergy. I mean, this is not just unique to the urban communities. It's really, I'm disappointed that the national clergy hasn't better embraced the war on drugs as a failure and medical cannabis at a minimum. But I feel like that's part of the competition with this message. What do you think about that?
I think that's true. I think there's definitely work to be done with the clergy to educate, because they've got such, power in swaying people and educating them on cannabis as medicine, and medicating doesn't equal high. That's not, they don't equate.
It's tough. I know, because it's hard for anyone in the leadership with all, because the damage of the war on drugs is, how do you advise a community that's being, war torn apart? You can't, it's hard to, the first message to be, we got to end the war on drugs. It's usually stay away from the dope, and everything gets thrown into, and I get that. I don't know. I feel like I think some of the issue, I have clients in Wayne County, Detroit, and I just feel like some of it got too much too fast. You know what I mean? It was like a good thing. They were servicing the community, and then I don't know, I feel like too much business in the face of the community, and they missed that evolutionary step of embracing and working and developing. Jamie Lowell wants to ask a question.
Yeah, we don't have that much time, but I just want to say the organization was in Detroit on Saturday, and in terms of the information, it was one of the best, most informative seminars that I've been to. They had Neil Franklin, Leap, obviously, the executive director, Dr. Knox from Oregon, one of the most informed medical doctors speaking about cannabis whom I've ever heard. Jesse, who was the chair of the organization, was there, and Councilman Cushingberry from Detroit. We're
good friends with Cush. Yeah, he's a great guy.
And it was very cool. And Jay from Dab Wars, who was also a member of Sons of Hemp, who she mentioned. And,
sure.
And that's an excellent organization in Detroit.
Triple. We got about 30 seconds to the break. This is fascinating. To tell people if they want to donate or get involved, who they should contact, and what they can do to help out.
Great. So our website is minoritycannabis.org, and you can sign up to be a member. You can donate, and you can get involved in any of our programs or find out where our next event is, all on the website. So minoritycannabis.org.
Excellent. It was great talking to you. Look forward to talking to you again down the road. Have a great night. Thank you.
You too. Bye-bye.
All right. I think we're running cue for our break. That was Jeanette Ward, right? Yep. And fascinating topic, and we'll talk a little about it after the break when we come back. And my timing is outstanding. This is Planet Regions. We'll be right back.
Planet Green Tree Show is produced in association with and made possible by the Michigan Medical Marijuana Association. Co-host Chad Carr, news director Rick Thompson, produced by Jamie Lowell. Copyright 2016.
But there is one voice that has never been heard before. The voice of old Mr. World himself. The way he might sound if he could speak to us in our own language. Mr. World, how was this wonderful, orderly earth of ours formed in the first place? And how long has it been going on?
Well, if a few people do decide to swing one way or another, it might actually pass.
This property was used to grow manufacture marijuana.
And the judge said he needed a timeout, so he took his belt and his shoes and his tie and put him in the lockup.
We're traveling through a dimension both of sound and ideas. We're at a place where the mind can comprehend and devise a wireless transmitter, measure time and light. Astonishing? Perhaps. But you can find it in a place that's known as...
Attention, ladies and gentlemen. The Planet Green Trees Show is underway with your host, attorney Michael Komorn.
We're coming back. Hold on. All right, we're back. Thanks for staying with us. And without further ado, we are going to jump right over to Rick Thompson, who's hanging from the wall over there, to do the news upside down. Thank you. Rick Thompson.
Upside down, I'm even more sexy. Hey, I'm Rick Thompson. It's August 18th, 2016. I don't think the studio audience agrees with that last statement. All right. The U.S. Department of Justice cannot spend money to prosecute federal marijuana cases if the defendants were in compliance with state guidelines permitting the drug sale for medical purposes, said a federal appeals court in the United States 9th District on Tuesday this week. Oh, the ruling from the 9th U.S. Circuit Court of Appeals comes as voters in nine states will consider allowing different uses of marijuana this November. 25 U.S. states currently allow for medical marijuana, and 26. Ohio has passed a law, just hasn't implemented it yet. While the sale of cannabis is still illegal under federal law, Congress in 2014 passed a budget rule prohibiting the DOJ from using federal funds to interfere in the implementation of state marijuana regulations, called the Rohrabacher-Farr Amendment. Due to this rule, defendants in 10 cases in California and Washington argued in their district that the federal charges should be dismissed. The Ninth Circuit's decision came from San Francisco, which covers 9 western states, and they ruled that the DOJ could not spend that money, just as the law said. What do you know? It works. Speaking of California, Los Angeles, a new poll released today finds that L.A. residents overwhelmingly believe patients should have access to medical marijuana through delivery services. 75% of residents are in favor of reforming their current laws to allow for medical marijuana delivery. What else did those voters say? Well, they also say 75% of them want delivery. They also believe in medical marijuana. 90% of LA residents agree that a patient should be permitted to use medical marijuana under the direction of their doctor. And 75% say marijuana is here to stay. Bans are not effective on controlling cannabis distribution. You know, I just talked about 9 states having cannabis law reform initiatives on the ballot in November. That's true. At least 9 states will charge ahead with marijuana initiatives on ballots in November, and that's a record number. Now, that's even despite the DEA decision to not reschedule cannabis that happened earlier this month. In 5 states, California, Arizona, Nevada, Massachusetts, and Maine, voters will be asked to legalize the recreational adult use of marijuana. 5 states. Meanwhile, those in Florida, Arkansas, and North Dakota will vote on a full-fledged medical marijuana program. Montana voters will be able to decide whether to loosen restrictions on their state's existing medical marijuana program, which they really need to do. Now, voters in Oklahoma also have a medical marijuana initiative on the November 8 ballot, and Missouri and here in Michigan. Petitioners are embroiled in court battles over signatures tossed out, leaving them short of the threshold required. We are still battling that, several of us on the board and this broadcast right now. Officials in Oklahoma have had their results certified by the Supreme Court there. Paul Armentano says the number of states voting on marijuana initiatives in 2016, unprecedented. You know, when you start reforming marijuana laws, you have some haters. And The Hateful Eight was a very popular movie recently. The Hateful Eight of Marijuana Opponents has been listed out by the website steamit.com. The first one, Carla Lowe, who was a substitute teacher in the 70s, now leads California Citizens Against Legalizing Marijuana Calm, and she's been fighting marijuana legalization for almost 10 years. James Lankford's on the list. Lankford is an Oklahoma senator who proposed a bill that would punish tribes, Native American tribes, for growing or selling cannabis by stripping their federal funding. What a dick. Nancy Grace, described as a shrieking bag of southern poo. We know who she is. Kevin Sabet, no list of prohibitionist jerkwads would be complete without including Kevin Sabet, who often says use of cannabis significantly decreases IQ, is 10 times more dangerous than the marijuana of the 60s, and that it addicts 1 out of every 6 children who try it. Also on the list of the hated 8, Chuck Rosenberg, head of the DEA. Scott Pruitt, Colorado Governor John Hickenlooper's guy who is an attorney general who's really a jerk. Debbie Wasserman Schultz, former leader of the DNC. Jeff Sessions, Alabama senator. And that completes the list of the Hateful Eight. Concluding the news for August 18th, 2016. It's Rick Thompson. See you on the other side of the commercial break. Bye.
The Planet Green Trees Show.
Hey, this is Willie for Normal. Have you ever met anybody before who's been busted on marijuana charges? This year in our country, over 850,000 citizens are arrested on marijuana-related charges. That's another marijuana smoker busted every 35 seconds. 90% for possession only. For the first time since marijuana was made illegal in 1937, Congress is finally looking at a bill to re-legalize marijuana. The U.S. Congress is considering legalization that permits individual states to set public policies that will allow them to legally control and tax marijuana. To find out more about this important congressional bill, please contact NORMAL at 202-483-5500 or on the web at normal.org.
The life I love is making music with my friend, and I can't wait to get on the road again.
Fantastic guest bloggers, incredible photography, and cutting-edge information separates the Compassion Chronicles from all other websites. Sign up for your newsletter today. Since 2012, the Compassion Chronicles has been delivering news and information for Michigan's patient community and beyond. From breaking news to science articles to networking and event information, Michigan turns to the Compassion Chronicles when patients and caregivers need to know the score. Edited by Rick Thompson, winner of the Crystal Trichrome Award for Journalist of the Year and named Citizen Activist of the Year 2015 by the Weed Blog. TheCompassionChronicles.com.
Join the Michigan Medical Marijuana Association today. MichiganMedicalMarijuana.org. The MMMA is focused on the well-being and safety of medical marijuana patients. The MMMA site provides the most comprehensive and up-to-date news on legal issues, politics, research, cultivation, as well as the various strange products and methods of cannabis use. Come join the discussion with the most knowledgeable and passionate advocates in Michigan today. MichiganMedicalMarijuana.org.
And now back to more Planet Green Trees.
Alrighty, I think it's been an hour, and got about an hour left. Stretching out a little to make it. Don't tighten up. Everyone drink some water. Fluid up here. I'm going to cramp it out. We're going to talk about this case again. I want to revisit it. I've read it a couple more times now. First of all, I don't even know where to start. There's a real fantasy. Is Shiler allowed to talk? Is he ready? There's a real fantasy that goes on. I love this. This is my favorite part. It is so. This is not Federalist, but and you know these guys. Aren't these the guys that you were drinking with? Just kidding.
Tell the listeners what you're talking about.
I will tell you this. So they talk about how there's no definition for plant. We don't know where to go. We looked in the dictionary. We couldn't find anything. We didn't know where to look. We're looking. We can't find it. Oh, what are we going to do? And then we're right back to where we started. Were these clones still just leaves, or had they progressed to the point that they were suitable for planting? That was not where they started. They didn't start anywhere. No one asked them to pose that question.
But also in
Go ahead.
That question, implies, not the question of what is a plant, but they're already assuming it's suitable for planting as necessary.
Of course.
That's
my point. That is not a way it was framed. There's 20,000 other ways to frame it, which would be like, how can we find a way to make this a unarrestable definition? That's what they should have been doing.
Here's the thing. Like I know I always say it, but when we read these Court of Appeals opinions, it's really hard to try to make it work in our minds when we know it's just
goobly gop.
Yeah.
Can we say that? This is not. Aren't these guys Federalists? Don't they show up at your clubs with
come on
bow ties? Just kidding.
No, but I mean, again, like I said earlier, why didn't they just go to the Public Health Code where a plant is specifically defined?
They use the definition of marijuana on the last page. Use the definition of marijuana from. I don't think it's that far away. Maybe in the same section there, right?
It is.
You know what they did? Here's the best. Here's the best. When they go look for a definition, they go to federal law.
Yep.
Why?
It's only used in sentencing purposes.
Only used in
sentencing
to
purposes.
hurt people.
That's a bad
to hurt
definition.
people.
Yes.
It's in the conviction sense.
Correct.
They could have gone to any other state within the medical marijuana. They go to Idaho for a federal case. I mean, they could have gone any other state and adopted that, just thinking progressively. Why would we do this if there's, other states that have, wrestled with this issue and come up with a sensible solution of how to define it in light of the fact that that's what these people are doing. They're growing marijuana plants. Let's recognize the gardening process of needing to clone.
It's a bad case, and we're just going to live with it until it's inevitably reversed, and that's it. But again, it doesn't. But from a practical standpoint, what is a caregiver, to do? And again, don't give yourself problems.
You think this will be reversed?
If it's accepted, yeah, it's terrible. They just
it is terrible, but the Supreme Court has not impressed me.
Well, the first thing that you're supposed to do in interpreting the law is look to what the statute says, and they say we couldn't find it. It's right here. I just read it. I just read it. It's MCL 3337401E.
Cuddly.
Excuse me.
It's in the charging statute.
Is it?
For manufacture? It's the last subsection of the charging statute for manufacture, delivery, and possession with intent to deliver.
I never really get that far, but let me hold on a second. Let me look at the complaint.
It's bizarre. Like that's where it applies, is in that entire section for sure of the charging statute. And so why they wouldn't apply it to the MMMA, which is essentially what they're trying to harmonize with, it truly boggles the mind on the level of Carruthers and some of these other opinions they've rendered, just where they've just completely missed mixture preparation thereof. Oh, we just ignored that part.
Yeah. There's part of me that thinks that maybe we're not getting the whole thing, and that's where maybe we just have some bad appellate judges. They're just poor appellate writers. I'm not trying to defend or anything, but perhaps this was an issue that should have been argued at the trial court, that this is an issue of fact left to a jury. I don't know if they did that in this case.
They don't seem like good readers to me.
I just can't make sense of this opinion, and that's just like the last Court of Appeals opinion.
But you just said you shouldn't try to make sense out of it. You try to make sense out of it.
I have to advise people.
Well, sure.
Means.
You've got to follow it, but you can't understand where it came from because
they're
we know
politically willful.
Exactly.
Well, it's the definition for purposes of the Public Health Code. Has it produced cotyledons, whether it's a cutting or not?
That's it.
And that's it. And a cotyledon, it comes by definition from a germinating seed.
At what point where is the problem? If it's a cutting and it then counts as a plant, so what's the difference between being able to see the roots on it or it just being a cutting?
So I'm not going to give you my answer because that's what the Court of Appeals, I think, tries to address. And they address it later in the opinion when they talk about like officers basically going in. And they basically say when it's just visible to an officer, which is entirely made up again. But it lacks scientific rigor. So basically, officers are going to simply say, "Hey, I saw some cotyledons, and therefore it's a plant."
But you can't.
But we can see the significance here, though, because if you're defining a cutting as a plant, then obviously you get to jail people for having far too many plants, and otherwise it's just litter that was on the floor. As far as cloning goes. It's hugely significant, especially where patients are concerned, and that's one of the functions Planet Green Trees provides by giving common sense answers to people, because a lot of people don't think clones count. They don't think they count until they go into the veg room, and that's absolutely a misinterpretation of the way the courts view the act, and the way most of us read it in 2009.
No, it's dangerous, but they shouldn't count. And I think we all agree that the clones, they shouldn't, but they absolutely do. And
the idea that
that's correct. They
I'm
absolutely
allowed to have 12 but not 13.
Right. And that you go to jail for 13.
Yeah,
that's a technical violation.
That's a problem. But anyway, we're getting off track.
A violation of the Michigan Medical Marijuana Act does not and should not automatically mean a charge of a felony. There are ways to deal with this, and by no means are those two things. Here's something else.
Revocation of your card.
I wish subsection K
and disqualification of all your
subsection
rights.
K of section 4. I wish it didn't have any language about and other charges that might be able to be pursued, because I think truly when the person was writing that, a violation is supposed to be a 2-year, $2,000 crime. That's what I think how it was supposed to be written. Not where you can just charge whatever the hell you want and basically say, "Oh, you got a technical violation."
That's a good point.
But they like it better that way. You can't, you can.
It also was not supposed to be a violation to sell to other cardholders.
Yeah, okay. Well, that's thank you. Thank you.
And to its credit, 7E should cover that.
Yes.
Yeah.
It should.
A liberal interpretation of the law, as is supposed to be done with the voter-directed initiative, would yield that type of interpretation, as opposed to a rigorous and detailed, strategic adherence to the minute letter of the law, which is absolutely not the way voter-directed initiatives are to be interpreted.
Kavanaugh's dissent to McQueen outlined the liberal argument to this, which would have solved all of these problems, prevented them from happening.
For those that looked at Planet Green Trees for legal advice and concerns and pointed out some of the problems, let me draw everyone's attention and open up the conversation about this paragraph. So as the opinion winds out, they're basically saying if we haven't done enough damage at this point, let us go a little bit further and just clearly crap all over this. And it goes something like this. Finally, defendant argues that the trial court erred in finding that he had delivered marijuana to another occupant of the house, blah, blah, blah. We disagree. Really. We reviewed de novo, blah, blah, challenges sufficiency of evidence in a bench trial, viewing the evidence in light most favorable to the prosecution, determining whether the trial court could have found the essential elements proven beyond a reasonable doubt. Defendant presents a brief argument in support of his position. He first argues that there was insufficient evidence that he delivered marijuana to the other defendant. What that means is that they charged him with the crime of delivery of marijuana, and there was no evidence of that. And then in this appears saying, but he's charged generally under 7401, which includes manufacturing, possession of intent to deliver, and delivery, when he's defending a delivery. They have to give him this notice issue right here. This should not be even discussed in these contexts. It shouldn't be and or the other. It's one or the other. It's not both. Anyways, so they go on to say here that defendants, This is defendant first argues insufficient evidence on delivery. It's unnecessary to prove delivery, as the charge is supported by possession with intent to deliver. And then they footnote 7401, which is laughable. Defendant does not argue that there was insufficient evidence to support the conclusion that he possessed marijuana with the intent to deliver, so he fucking loses.
Oh, I see what you're saying.
Yeah.
You're saying that, the court should have recognized that merely possession with intent to deliver does not mean possession with intent to deliver to trailer.
No. I'm saying, to me, the defendant says, look, I'm charged with delivery of marijuana. It's a statutory charging. It says delivery / manufacture marijuana. And then in what they allege you did wrong, it's usually you manufactured illegally, you possessed with intent to deliver illegally, or you delivered. So it's one of those three. It's not or any of those three. It's one of them. And when they charge you, you're defending against either a delivery,
right,
a manufacturer,
I get it.
That's or PWID.
That's why you have multiple counts.
Exactly.
There you go. But they didn't do that. They're saying, I'm defending this conviction on my delivery because there's no evidence of delivery. Like, ha. The statute that you're charged under, we're going to throw out, it could be any one of these, and there was some evidence of your intent to deliver the marijuana that you possess. Why?
Understood.
Why? Because you had seeds
That's good.
Stems and shit from your pipe that you scraped out of. Think about that. That's what they're talking about here. That's what they're talking about. This is the most offensive crap I've ever seen in my life. Read what they say. And defendant doesn't argue there was insufficient evidence of the possession of intent to deliver. He argued that the relevant material found in the room consisted of seeds, stems, and residue. That's crap from a pipe or a bong or something, right? Which are not considered usable marijuana under the MMA. He so argues. But what constitutes usable marijuana under the MMA is irrelevant to what constitutes marijuana. What? What is that?
I don't know.
What is that?
That means we're fucking awesome. That means that's
What
exactly what
is that? It's irrelevant.
Are they
How is it
even
irrelevant?
lawyers? The
How is
Court
it
of Appeals
irrelevant?
just-
It is defined
They're
as
cops.
not.
They're
Consi-
cops.
this is the Court of Appeals. They're not police officers.
I don't know.
They
I
might
don't
as
think
well
they're
be.
lawyers.
And I'll tell you this: what they did, their adopted opinion here, is verbatim out of the MSP manual of what a plant is.
Of course it is.
You know
They're
what's-
cops.
You know what's great is
I'm telling you, if you look up how to do it and the way that they do it to define it, they're called as an expert. They went in, they got this login, they went on there like, okay, let's make it easy. And there's a line in here about making it easy, and that's the way we do.
How do we write down how they do it?
No, we said
Hey,
this
cops,
is
just
this
send
is-
me up to the verbiage you want me to use. Why
This
don't you
is
just
how-
send that to me? And
I guarantee they use the words root hairs. It's in every police report.
Right.
I looked at them. They had root hairs. That's what they call them. I'm just saying. It's in here. Didn't they use the phrase root hairs in there? I swear they did.
they did. Root ball is a popular
Root.
one too. But that's like actually
I just the root hairs just really strikes me as
Well,
funny, and it's such a copism to me.
Well, and if you've ever seen big long roots coming off of plants pulled out of a cloner, you know exactly why it looks like we call them beards sometimes, the big white beards.
Root
you see why
hairs.
root hairs are kind of an appropriate name for some of those things, but
I'm hung up on this. Help me here, Mr. Federalist. I'm back to page 2 of the opinion. It's got, there's no cases in Michigan that provide assistance. There are decisions in other jurisdictions. They looked at the Sixth Circuit, which is Michigan, arguably, in determining what constitutes a marijuana plant for purposes of the federal sentencing guidelines. Concluded that marijuana cutting is a plant for federal sentencing guideline purposes. There's readily observable evidence of a root formation. They then go on to say marijuana cutting with root ball or root hairs easily meets this test. The court concluded that this definition would be easy to apply. That's where I'm talking about. The court would be easy to apply because we already have the witnesses who will do that, right? The lab people to identify if they're going to do that, or the police officers, and comports with the plain and ordinary meaning of the statute. And they do the little footnote 5 there. They're referring to the sentencing guidelines.
They're referring to the case.
Yeah, the case in the Sixth Circuit case of that uses it in the guidelines of what a definition is. Like they refer to it as if there's a statutory definition that is not. It's such a falsity. It's like they're referring to a case that issued an opinion regarding the definition of a plant and relied upon the statute of that in the federal guidelines.
In federal court,
Yeah.
where there's no marijuana protections whatsoever, medical marijuana protections whatsoever, for the purposes of sentencing.
I know.
Okay.
I like the part in the middle here on page 3 where they're like, and just so we can pat ourselves in the back, many of the other federal courts have gone here as well, so we are that much more confident in.
if they've gone there, then where's the definition they came up with?
Well, they didn't actually come up with
Root formation as the guidelines. So, what does everybody think? I think we're going to talk about it. Do we have time? All right. What's the conversation here? Jim, you like that? I think you're a big fan of that. You're actually friends with Murphy, right?
No,
Just kidding.
no. What
Murray.
I'm a big fan of is this court's taking a step back and interpreting this law as a shield for patients and caregivers, as opposed to constantly trying to poke holes in it and throw people in prison.
30 seconds.
Good answer.
We got to give more time to the police officer. Who else
Right.
wants it?
Steve Miller came into the studio audience. Steve Miller, everybody.
We got 30 seconds.
Hello,
We
glad to
need
be
more
here.
time. Please go.
What's a plant?
What was the question?
What's a plant?
What's a plant?
Yeah.
Too late.
Root hairs.
All right,
I agree
the
with
break's
Chad.
happening right
Boom!
now. The break's happening.
Thank you.
So, but we'll come back and we'll get some more. Are we giving more commentary on this? No. All right, that's what we're going to do. Yeah.
Planet Green Trees Show.
Join the Michigan Medical Marijuana Association today. MichiganMedicalMarijuana.org. The MMMA is focused on the well-being and safety of medical marijuana patients. The MMMA site provides the most comprehensive and up-to-date news on legal issues, politics, research, cultivation, as well as the various strains, products, and methods of cannabis use. Come join the discussion with the most knowledgeable and passionate advocates in Michigan today. MichiganMedicalMarijuana.org.
Fantastic guest bloggers, incredible photography, and cutting-edge information separates the Compassion Chronicles from all other websites. Sign up for your newsletter today. Since 2012, the Compassion Chronicles has been delivering news and information for Michigan's patient community and beyond. From breaking news to science articles to networking and event information, Michigan turns to the Compassion Chronicles when patients and caregivers need to know the score. Edited by Rick Thompson, winner of the Crystal Trichrome Award for Journalist of the Year and named Citizen Activist of the Year 2015 by the Weed Blog. TheCompassionChronicles.com. Attention. Get ready to write down a very important number.
Michael does not know how to fail. Second place is loser.
If you have a medical marijuana case and need legal representation, call the best, attorney Michael Komorn.
He's very passionate in the courtroom.
Getting the best outcome requires quick legal action, and it needs to start with one call, toll-free to attorney Michael Komorn. 800-656-3557. Write it down, 800-656-3557.
Michael Komorn gave us our life back.
Attorney Michael Komorn. Vigorous criminal defense.
Ram trucks are reaching new heights when it comes to capability and efficiency. The Ram Heavy Duty is the most capable full-size pickup on the road today. And the Ram 1500 is the most fuel-efficient full-size pickup ever. So what does that mean? It means Ram trucks are built for the long haul. Ram, America's longest-lasting pickups.
Here's Michael Komorn with more Planet Green Trees.
All right, we're back. Steve Miller's here. We're going to talk to him. Steve, welcome back.
Thank you.
Chad, take my microphone. Thanks. Good
Former
job.
cop.
4 weeks, 5 weeks in a row?
5 weeks in a row. So what about all this? What do you think about this whole plant thing? We were talking about this opinion earlier. You were here for that. It's not a quiz,
Yeah.
but what are your thoughts? I mean, what can you tell us?
I agree with what you guys were saying earlier. Why don't they go to what's the agricultural definition of a plant and leave it at that? I mean, why does it have to be so difficult? And just the twisted backwards language that you were reading off is, no wonder the police officers are confused. And when they're confused, they're going to err on the side of violating people's rights.
Right.
That's where they err.
And it really, that has been, it's a good point that Steve makes, I think, and all too often, the law enforcement community, they get, we all rail on them. Let's be honest. Okay, so, I mean, we do, but really the step back is it's not
deserved.
Well, to a certain extent, it's their job. This is not a defendable. I don't, but like understandable. Like they got to do the dirty work, right? And we know they got to go. And, they're doing, but there's been a real lack of direction and training. They've kind of, they being the leadership of the law enforcement community, not the officers as a whole. The leadership has embraced the ambiguity and kind of, left it out there as to do whatever they want to do.
Right.
And
very rarely do you have a supervisor who will err on the side of the rights of the person. What's going to bring in the arrest? What's going to bring in the forfeiture? What's going to bring in the bond money?
Yeah. I had a prosecutor who we were negotiating the forfeiture with recently say to me, and they got they just brought in the warrants. They're on my desk. I haven't signed them yet. I'm like, and you shouldn't, and why would you? Because I'm going to be right back. I'm going to give you more shit next time on that if you're going to do this. Well, the police are, I'm like, yeah, but you're the prosecutor. I understand. So tell me about that, Steve. You've had cases, you you've probably, and we're not talking drug cases, like our case. Remember,
So just interject. Steve Miller, a former drug detective, local LEAP speaker.
Yeah,
this is from his perspective. We just didn't mention that.
I'm saying though, I'm talking non-drug cases. Looks like an assault or some in like our case, and you've already you've solved the crime in your head, kind of to a certain degree. You've written up your report, you take it down there, and what's that process? The prosecutor grabs it, signs it, and says, "Go get him," right? I mean, and then you go swear it out, and it goes into the system. What is that check and balance there? Like how much the time that you presented a warrant for for charges as a lead detective, how what's the kickback on that? I mean, did they ever tell you like, hey, it's not enough here, go get some more witnesses, or what's going on? Does that ever happen?
That has happened, yes.
Okay.
Prosecutors will send it back. There's not enough. You don't have enough to prove this case here. And it does happen. I mean, there is checks and balances in the system that way.
Does that mean, is it frequent or not? I mean, do you know things like this happen, like who the on-duty prosecutor is, and you may wait till the morning until that person's off.
Absolutely.
There you go.
That does happen.
Sure it does.
Yeah.
Or who can we go get this warrant from? We're not going to,
Yeah, we don't want to go to
Judge
so-and-so's
Liberal.
house. We're going to go over to Westland.
Sure.
To the magistrate.
Right.
He signs everything. He used to be a cop.
Sure, sure.
That's, fictional circumstance.
I got it.
Do they
That's how
talk
it
just
goes.
like that?
You know what? It's totally okay. That's how it goes too, right? Am I right? There's nothing wrong with that. There's nothing wrong with that. But the question is, do you guys have a policy of having them the affidavits reviewed by the prosecutor
For search warrants? Yes.
always?
Yes.
That's good.
That
It's not
was-
required by law. Who would deny
No,
that?
not all departments do it.
It's not required by law. Anyone debate that? Tom Loeb and I had an argument about this the other day.
What, that the prosecutor review it?
That there's a requirement statutorily that a prosecutor review an affidavit before it is submitted to magistrate or judge. True or false?
I would say false.
I say false.
It is false. There's no mandatory anything. Because there are those officers out there who do it all by themselves. They exist, right?
They're go-getters.
You have any old schoolers?
The go-getters.
The old
The
schoolers,
do-getters.
like, I don't need to call the prosecutor. I know what probable cause is. Right?
Right.
There's probably people,
I don't need a silly law degree.
There's a guy in Lapeer that does that. I don't know if you know it.
Old school.
Old school. Envelope pusher. The pusher of the envelope. Anyway, so what would be the thing, so that does happen. But my I guess the point I was trying to make was that this prosecutor is complaining to me that they brought the charges. I don't know. At what point does it end? At what point did you not get enough, out of it? If you've fought and litigated a forfeiture case, but this is probably adverse or different than any of the cases that you're talking about. Where you've been involved with the litigation of a forfeiture case and resolution of the parties, and then turn around and charge someone criminally, like that's just when does it
Right.
end, and who's running this? Who's running the show here? Why do we need to do this at this point? But I mean, that's probably more uncommon, isn't it? Would you say so? Anyone like to jump in on that? Where like a forfeiture litigation takes place, and then after the litigation,
Then
start
they
up
charge them?
It happens.
I've heard
Turn
of
his microphone on.
I've heard of it happening
It happens-
quite a bit, and they use the forfeiture as leverage.
Evidence?
Well, but they use it as leverage, and they say, if you don't come back for your shit, then we won't charge you. Then you come back for your shit, and all of a sudden, you have charges filed against you.
Do you know where that's happened? I mean,
I know for a fact. Well, it's happened up in I know in Clare County. It's happened before. I mean, it's kind of serendipitous that as soon as someone starts getting their stuff back, all of a sudden criminal charges are filed. It's kind of bizarre.
No, I hear that from people who just give me a call and they say, hey, I'm going through this kind of thing. And they ask me straight out, so what if I just simply pay them and will they leave me alone? And I have to say, of course not. Because in my experience, it never happens. And I've gotten a few phone calls from people who are just convinced that this one area of Michigan, like it's happening right now, widespread. Just they're going and grabbing and not charging if you pay them. So
Really?
yeah, and that's that's really, really not lawful.
No, that's criminal.
Yeah.
That's criminal behavior. That's unbelievable.
Technically, wouldn't that be racketeering?
Well,
They can do it.
state sanctioned.
I think they can do it. I mean, they can do it to the extent until there's a they're identified, they're going to get away with it.
The only way that it's going to stop
until
is
somebody puts it all together
Well,
and proves it. They have to prove it and prove bad faith. That's the problem.
Well, the point being
it's
that
a monumental
if they're doing a raid and the
How do you
property
even
is
find out?
the property is guilty by being associated with, loosely, friendly with, on top of, around, used, if then they're going to take it.
Yeah.
They're going to charge $30,000, $40,000 for the FOIAs necessary just to get the information to start to understand and comprehend the problem on these sorts of things. Like the effort. That's what I'm saying. Like you have to start at FOIA and then go from there and fight it at court. And especially with problems like this that are so widespread, where you're trying to prove a pattern of behavior. It is just a mountain to walk up. Like, we've got one that's very focused around one entity where they admitted their guilt in a thread of emails that they subsequently gave us. And look at how difficult it is to get them into a venue, to hold them responsible for what they've done.
It's not doable. It's not doable for 99% of the people out there. And that is why, short of reform where you're requiring a conviction to come take your shit, I don't see this problem going away. I think it's nice they're proposing to eliminate the bond requirement. I mean, that's all well and good, but your shit is still tagged at that point. And you...
What states is... I mean, they've really reformed civil asset forfeiture. Is it New Mexico?
Yeah, New Mexico.
Is it Minnesota? That one guy was from Minnesota who came to the hearings.
We're doing Band-Aids on arteries as a like really nothingness. But I was going to say, you reminded me when you mentioned the other state. They went, well, let's continue with this forfeiture stuff, because that other case did a little slap in the face by mentioning the Ricky Brown case, Jeff. Wasn't it? Wasn't that just insulting us?
They want the money. That's the main issue. They want the money, and they'll do anything to keep getting the money, even obstructing what should happen.
Exactly. That's why I was saying, in addition to what Jim said, that there should be the criminal conviction, the proceeds also should not go right back to the agency that took the items in the first place.
General fund, baby.
Let me ask this question. Does anyone fear that this U.S. Department of Justice memo minimizing the amount of private prisons for federal prison population is a memo to the state prison population to buy up those contracts? I mean, am I right about that? Is that not? I mean, this has nothing to do with because
No, I think it's the opposite of that. I think it's the initial death knell to private prisons. The market factors in a lot of this stuff, and I think that there are a lot of people that have understanding of this well beyond what we have that are investors.
Let me phrase it another way. Isn't it true then that where this population is going to go is not, the charge them in federal court? I mean, in state court.
No,
I don't know. I mean, I don't think there's been a reduction.
You can't just flip federal charges to state charges.
Yes, they can. They can easily. There's charges within state court that they can or will.
Yeah, but I don't think they make the decision on it based on whether or not they want to incarcerate them federally.
If the feds aren't going to take the cases and prosecute them, then the state will. And that's what's happening.
I don't know. I can't tell you this. Those federal prisons are very important to the local economies of those cities, even though I don't agree with the fact that we have them. Those private prisons put a lot of people to work, so there'll be a lot of pressure from the local communities to keep them open and doing exactly what they've been doing.
And
that just supports Michael's position that they're just going to flip over to state positions.
It's bad employment.
What I'm
it's bad
saying,
for
though,
the corrections officers.
I don't know if the same statistics are working with the state prison system. Like this was a statistical breakdown that there's less business, so let's cut off some of our contracts is one of the arguments. I don't know that the same is going on. Does anyone have any? Who's got the stats on the state prison system? I bet it's Schuyler.
What states are going to follow Obama into
not
reform,
many of them.
Not very many of them. And also, I'll note that just within the last few days, Corrections Corporation of America got $1 billion contract from the federal government to build refugee shelters. 3 times more capacity than they could possibly.
And still, their stock price has cut in half. All I'm saying is that the investors understand this calculus, and they're starting to price in the loss of these contracts. And the value of the company, according to investors, is cut in half in just a few days. So I think that as the truth comes out about these private prison institutions, about what a risk they pose to the communities that they're in, because they have poor security practices, I think that there's going to be more and more and more truth that comes out about the risk that they're posing to their own employees, the risk that they're posing to the communities that they're in, and I think that it's just going to unwind from here. They're just going to go into the toilet.
I hope you're right, Chad, but I'll tell you what, man. I've been to Pinal County in Arizona. It's right outside Maricopa County. And Pinal County is famous for its prisons. There's whole towns in Pinal County that will not exist if the private prisons go away. And I completely agree with Rick here. You're going to have, their stock price may have dropped. They still have oodles of money, and they are not going to let this go. And if the feds are not going to continue to incarcerate and fill their prisons, I believe they'll absolutely go to the states, the money-starved states that are going to do anything to try and address their bottom line, and it's already happening.
Well, we know where they're going.
You said the key, money
to house illegal immigrants.
They cannot afford to pay these contracts. It's going to get worse and worse.
Well, good for business. Prison
in those areas where they try to continue to incarcerate people within a private prison system that is poorly funded like that.
Well, and the problem isn't it that the contracts that they sign with the states or with the federal government require certain occupancy. Otherwise, there's penalty.
They absolutely do. That's right.
I mean, come on.
But you know what? But guys, let's look at the alternative here. They'll have to stop arresting so many people. Because when you put the state and the federal government in charge of these private institutions, prisons will close. They absolutely will, because the government will not be able to run them the way that the private corporations were, and they're going to spend more money. That is just bottom line, and that's a good thing, because then prisons close. But then they have to stop arresting so many people, or at the very least, they have to stop incarcerating them.
Right. Yay. Good. And
30 seconds.
There won't be a for-profit lobbying entity in Congress and in state legislatures consistently lobbying for longer sentences, mandatory minimums, and other types of really bad public policy
In order
measures.
for that to become true, you have to get rid of the external contractors from the existing prison and jail systems. Aramark is a perfect example of a shit show gone completely awry, and that stuff has to be eliminated as well.
Planet Green Trees.
Good point, Jim.
If you missed the last Full Melt show,
you missed a lot. No more.
That's what's been going on. There's been some civil litigation involving eviction. They're trying to say I have a big, mean, vicious dog. C-I-L, my landlord. Have you ever heard that sketch before?
No, I can't say I have.
Here we go.
Dark and lonely on the summer night. Shoot my landlord. Shoot my landlord. The white dog barking. Doogie bite. Shoot my landlord. Shoot my landlord.
I'm sorry. I'm upset, you know? I get lost. I'll get lost in a sea of verbiage.
Do you want me to keep like a fly swatter on hand or something?
Go ahead.
I mean,
Just
you
give me the smack.
You went off there for a minute.
Just give me the smack, and I'll be like,
right on the back of the head. It's okay, guys. I'll keep them in line next time. I promise.
I've seen things no man should bear, and those that every man should dare. From the beaches of Normandy to the far reaches of the earth. In my life, I have lived millions of lives. I've outrun robots and danced with dinosaurs. I've faced the faces of fear and fortitude and witnessed great beauty in the making. I've kept the company of kings and queens, but I'm no royalty or saint. I've traveled, trekked, wandered, and roamed, only to find myself right where I belong.
Jeep. See your authorized Jeep retailer for details on how you can become a Jeep owner.
RootMetrics, in the nation's largest independent study, tested wireless performance across the country. Verizon won big with 153 state wins. AT&T got 38, Sprint got 2, and T-Mobile got 0. Verizon also won first in the U.S. for data, call, speed, and reliability. AT&T got text. Stuck on an average network? Join Verizon, and we'll cover your cost to switch.
Attention. Get ready to write down a very important number.
Michael does not know how to fail. Second place is loser.
If you have a medical marijuana case and need legal representation, call the best, attorney Michael Komorn.
He's very passionate in the courtroom.
Getting the best outcome requires quick legal action, and it needs to start with one call, toll-free to attorney Michael Komorn. 800-656-3557. Write it down, 800-656-3557.
Michael Komorn gave us our life back.
Attorney Michael Komorn. Vigorous criminal defense.
Play-Doh Compound can help kids practice communication skills. Start by presenting the visual of the letter or word. Then ask them to mold the Play-Doh compound into the shape of the letters. It's an effective way to foster speech and even writing.
And now more Planet Green Trees.
Alrighty. Welcome back. Thanks for staying with us. Got about 15 minutes left, is that right? Ice cream is...
No, there we go. Perfect.
All right. So, are we done with that topic on the prisons thing? Or Chad seems to be very vocal tonight. Do we want to let that... maybe just for the purpose of not hearing from anymore, we just want to move on.
I think everybody's excited. I mean, I don't think there's anything else to say. I think the privatization of the prison system gives all the wrong incentives, and it needs to be stopped. So,
but no one's talking about state law. Fine, we're going to keep talking about it.
It's a step in the right direction.
For the feds, right? Okay. Right. But I don't know. I mean, I think the states aren't following them into that. I don't think that's taking place.
I think that's an accurate statement.
And I think that...
Well, it's a little early, though. We just
Rick.
We just got the federal move. What's the date on that letter there?
Sure, absolutely.
Yep, it's just very, very early, so we don't really know what the state response is yet. We can be optimistic about it.
Okay.
Yay. PGT optimism, yeah.
All right. Cautious optimism is the best I could offer or relent to.
I just think it's such a rotten system to the core.
Okay, here he goes again. Let's talk about something else.
As it starts to
listen,
be
there's
looked
another important thing in the news. But this is almost equally as fun for you, Chad. The Ninth Circuit remanded a case in California about whether the DEA could prosecute a case in federal court, and they recognized the Holder memorandum, saying that they were not going to. They're more specific about. It wasn't even a Holder, was it? It was
it's the Rohrabacher Farr Amendment, because I covered it on the news. Yeah.
Right, but the point being that they remanded to the court, and the question is, what impact, if any, did it have on the state of Michigan's medical marijuana program?
It says that the federal government can spend money in going after citizens who are strictly complying with medical marijuana laws in their respective, or the marijuana laws in their respective states. Strictly complies with. So, I'd suppose that,
In Michigan, we don't see a lot of 11-plant federal cases.
Right, but you do have dispensaries and compassion clubs and things that the state government has taken the position are not allowed under state laws. So, the feds could slice it a different way. There's always cop logic that would say, we're going after, they're doing the same thing that the Michigan cops are doing already, going after them and saying, well, they're not in strict compliance. Yeah. As the other thing is, on a more positive note, is it says that they can't lend, they can't give resources. What does this do to any regional multi-jurisdictional task forces in the participation by any federal agency like Border Patrol or Homeland or DEA or any of these guys in any of the state's multi-jurisdictional task forces.
I think they'd probably be able to continue to participate, but certainly not in the investigation of medical marijuana crimes.
Well, is there any effective way to build the Chinese wall and say you can't do
But they wouldn't be
marijuana?
investigating medical marijuana crimes that are in strict compliance.
Well, how do you know?
Exactly. There's no such
their
thing.
job would
There's no such
shift.
thing.
Yeah, their job
Here's something that I think would be.
They'd have to presume that everyone was in compliance.
I'd like to believe, however, that the way this would be cut, the Ninth Circuit opinion, would be that because the case was remanded to the state court to see where was it, California,
To see if they were in strict compliance with state law.
The state law does not have a law. Does not have a law on distribution. It has a law on, medical growing and an affirmative defense only. So this creates another. So my question is, if they're going to do that and say, okay, if we sent your case with 13 plants, which is not anything that they would do, let's say it's 1,000 plants, okay, and they got 1,000 patients. They're not in compliance with the Medical Marijuana Act, but they could be defendable. You tell me the feds would have to, if they are taking the steps of, excluding the basis by which they would get immunity, then they have to recognize the other side of it, which is a defendable position.
Right.
They would have to.
Are you saying it was sent back for them to put on an affirmative defense, effectively? There's only an affirmative defense?
I thought that they remanded Shiloh, confirm or not. Didn't they remand that back to the state court to see
if they were in full compliance? What I don't know is whether full compliance is...
They don't have... There's no
only
immunity.
Right.
There's no such thing that's a defendant.
I think you're right. And
So
in
it's
Colorado, I think it's only Section 8 defense.
In California.
Effectively in California. I
right.
think you're right. So what does that do? That's a curious situation.
Because it was Michigan, then there's there's no strict compliance. There's no explanation for the.
Michigan is actually better than California.
I mean, in that there's more of an answer.
There's an immunity.
Yes, there's an answer to that question.
But
they only have an affirmative defense.
Are you in strict compliance with Section 4, Section 8? Right.
Well, what I'm
send back to.
But we have both.
Strict compliance with an affirmative defense is basically what they're saying.
Right, and therefore...
But there's no bright lines in Section 8, though. There are bright lines in Section 4.
That's the point. There's no compliance. Whatever it is, it's defendable.
So the feds say no. If there's no strict compliance, if compliance is
I think that's what they did. Their benefit, if they get back down there and they get in state court instead of federal court, they're golden, right? I mean, like to get sentenced under a huge marijuana, like the feds have them in a marijuana plant case.
Were they in compliance with state law? Yeah.
I mean, there's no compliance with state law.
That's what I agree with you. I think all they have is an affirmative defense.
So the question is, so what do they get? So the answer is they have to defend the case in front of a jury. They're either going to do it in federal court or state court. They're going to get the state court. That's what I mean. I would think.
Well, they're still in the civil action. It was remanded presumably back to the federal court in the civil action to determine whether or not they strictly comply with state law. I don't know.
I thought it was remanded back to the state court. Chad. Shiler's talking.
I see what you were saying, though, Michael. That's almost a win if you get it out of federal court back in the state court because you can avoid potentially federal
mandatory minimums,
exactly.
right? And they probably have less of a penalty in California. I imagine they've had some reform on marijuana sentencing.
But that would be the nice assumption, and I'm not sure that follows, though. If it's remanded, it could be remanded. I don't know.
Yeah.
I'll look it up. But it could be remanded just for the determination whether or not the person was in compliance.
But there's no compliance in California.
I understand that.
So
there is compliance.
Well,
it's called you have a defense.
You comply with your
you complied with the law. I still think
So one thing really quick, because it might just finish this issue. The court in the Ninth Circuit doesn't make an issue with distinguishing between the types of defenses in different states. It simply just says that in order we decide the prosecution's appellant violate, we must determine the plain meaning of prevent, in quotations, the medical marijuana states, and then in a footnote lists all of them. So they don't seem to differentiate at all. So I think all the court is saying is we're going to remand you back to state court to be basically prosecuted for the time being in state court, and then I would think if they're nasty about it, or at least the federal government would argue, is back to federal court for your sentencing now. Right. I think that's...
Well, no, they would charge you as well.
Well, I don't think so.
They can't try you in state court on a federal charge, can they?
Well, no, but
But they both can try you.
The state prosecutor may not even want to go forward, arguably.
If there's full compliance, right?
No, there's no full compliance. I'm saying they may not...
A federal court can apply state law. And that's what the federal court's essentially doing, is saying we're going to apply state court law here, but we're not going to do it in federal court.
So the federal prosecutor is applying state law to the defendant and is remanding it back.
Well, that's what he was forced to do here, and the court basically said no. And this is what the big win is, that we are going to basically have to make sure that you followed state law. They recognize that federalism issue. Yeah. That's what they recognize.
And when they go to this is the point. They're in federal court. There's a judge and 95 staff members and prosecutors and there's the defendant and a couple lawyers. That's how federal court is. Okay, you go to the state court, it's a totally different ballgame. It's like thousands of cases. Their desire to want to prosecute this may not be in the who's going to prosecute? It's got to be a state prosecution. Not going to they don't have any authority. Entitled to a jury, right? No, but the point is that they remand it
for an evidentiary hearing, I believe.
That's not. I think for what? I mean, you're right. That's what it would think. But evidentiary hearing on what? Immunity? No.
See,
it's an affirmative defense.
Well, I mean, the DOJ actually argued that. They argued that doing this isn't what the law requires. They argued that simply, doing that would basically negate their role, their efforts to apply federal law. That's what they argued. But the federal court recognized that states have their own laws. Great.
So what happened?
Their own police power.
Do you think they're going to appeal this?
I don't know. I have no idea. That'd be awesome.
So what's your?
I have no idea.
What do you think would happen in the Court of Appeals?
I have no clue. It's
See, let me give the conservative interpretation of this.
It's already at their Court of Appeals.
Well, this actually is a federalist issue. They came to a good decision.
Yes, and I would say, the advice for all is that it doesn't mean, what it means to me is if the feds are and want to go after someone that's a medical marijuana patient and they want to arrest you because you're outside of Section 4, I think they can do that arguably. I think they may run into the problem of needing to explain whether or not there's a defendable position there. You know what I mean? If they want to go there, and that's the point. Like if they want to go there, 2 minutes. If they want to go there, they have these issues they have to deal with. It could be the end of it to a certain degree.
That's it. When I read it for just basically the first time to skim, that's all, frankly, I've done. It was basically, okay, this is the sigh of relief case that it wasn't really in the forefront of my mind, but if the feds did come in, state law would matter somewhat.
But at the end of the day, the feds have not been ever present in the Eastern District.
But not
much,
in Michigan.
Western District much more. A lot more cases.
But,
this is not an invitation for the feds to participate with the state police to strictly for strict compliance with state law.
That's fun. because that actually does get into some issues. Often, you hear stories about states, like local chief calls the DEA agent that's been the liaison.
Let me ask you this.
Because they have an issue in their town they want to investigate.
Let's say we're going to trial. What's everyone's opinion? These two right here. The opinion, we're going to trial tomorrow on a case from 2010, pre-memo. But we're going now, and the first witness in the state case is a DEA agent. Objection. He's being funded by funds.
If you're going to do this tomorrow, I'll just read it right now.
He's here. He's here participating
illegally. It's the funding. Are you getting paid?
He spent money on gasoline. He had a sandwich.
I'm just saying, hypothetically, it may be tomorrow. Could be, but I'm saying, can a state? Is it quite? The better question is, can a trial commencing after this case,
I think,
involve calling a DEA agent 3 minutes?
Probably retroactivity.
I think it'd be smart to bring it up, and the standard of review is whether or not it's for the carrying out or accomplishment or giving practical effect to ensure actual fulfillment of this concrete measure.
What?
That's what they basically say. The interaction that can take place.
How about at the time? How about at the time when the DEA agent was asked what he knew about the Michigan Medical Marijuana? He said, "I have no idea." What compliance is and what is not.
A whole new area to litigate. This is the problem.
This is the problem.
There needs to be fewer laws. There needs to be fewer laws. That's the only.
It's the Full Employment Act.
It really is.
60 seconds.
I mean,
that's fun.
I mean, have you seen the rents in Detroit on 8 Mile nowadays? It's insane.
It's nice.
I paid by the hour.
It's
I reviewed some client documents the other day, and his taxable SEV is $7. And meanwhile, his rent is 20 times what he's charging.
That's right.
All right. Okay. That's a thing now.
It's a good investment.
Detroit and Greg Pulaski's probably owns that property. All right, I think the show's over. Is that it? Did we just call it?
That's it.
Thanks, everybody. We will talk at you next week.
10 seconds.